Judge, reviewing the defendant's motion, the first point of contention I would have is that there's no traffic stop. This is a casual encounter. If you look at State v. Daniel, which is a court, a case out of Knoxville, it articulates our well-known standard that in Tennessee,
Citation on that?
12 Southwest 3rd 420. It's a case from 2000, January 2000. So it is from the Supreme Court of Tennessee. Articulates that there are three distinct types of police-citizen interactions. One being a full-scale arrest with probable cause. Two being a brief investigatory detention, which must be supported by reasonable suspicion. And three is a brief police-citizen encounter, which requires no objective justification. The case goes on to explain that while arrests and detentions implicate varying degree of protections, not all personal intercourse between police and citizens involves seizures. Only when an officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen may we conclude that a seizure has occurred. So yes, at the point that we've ordered someone out of the vehicle, we have a seizure. Up until that moment, there is no seizure. There is a consensual encounter between law enforcement and citizens. Even in Mr. Warren's testimony, they walked up and said, "Hey, what are you guys doing?" The window tint statute, Judge, if we were to look at that, you are very well familiar with this statute, 559107. And towards the end of that, we have a section that says it is probable cause for a post-certified law enforcement of this state to detain a motor vehicle being operated on the public roads, streets, or highways of this state when the officer has reasonable belief that the motor vehicle is in violation of that subdivision for conducting a field comparison test. I have heard Your Honor liken that to the requirement that we have to have a driver's license to drive on the roads of the state of Tennessee. It is a privilege that you get to drive on the roads. It is a privilege you get to have the vehicle on the roads. And so the state has imposed some very minimal extra restrictions, one of those being that your vehicle can be stopped. Now, looking at this articulable suspicion that Mr. Baker goes to, I'd first like to direct the court to State v. Smith. This is a unreported case. I believe it was cited in counsel's brief. It has a Westlaw citation, Judge. I think he had the Lexus citation. The Westlaw citation is 2005 Westlaw 2333632, and it's State v. Michael N. Smith, decided in 2005. In that case, and I looked very closely at the facts, it says that the officer noticed that the window tint appeared darker than allowed by statute. The window tint on the driver's side windows appeared darker than allowed by statute. Also perceived that the tint on the front windshield was excessive because it extended beyond the manufacturer's factory installed shade band. After observing the window tinting, Officer Campbell stopped the defendant. That is the facts in that case. In that case, the court found that it was reasonable, cited the exact portion of the statute that I just read, and then that case goes on to highlight if the officer develops reasonable suspicion that the occupant is engaged in other criminal activity during a valid stop, further detention is justified. So here we have a casual encounter, not a stop, but even if you were to find it a stop, law enforcement walks up and moments into the traffic stop, or moments into the encounter, law enforcement asks, "Hey, how old are you since you are sitting there smoking a vape?" We've got somebody underage, that's a criminal infraction. We didn't even get to the asking of the driver for her documents and registration because more developed in that stop before we could get that far. Judge, I'd also like to direct you to United States v. Bravo. That is out of the Middle District of Tennessee. The citation on that, looks like I printed this a while ago, so again, I'm just gonna have a Westlaw citation. That's 2015 Westlaw 1650278. It's the United States versus Jose Navarrete Bravo. Judge, this looks again at window tinting here in Tennessee, and that case reads that as an initial matter, the traffic stop was lawful. Officers may stop a vehicle based on the officer's familiarity with window tinting and their estimate that the vehicle was tinted substantially darker than permitted by law. It again did not make, when you go through the facts, they wanted to know exactly, could the officer estimate exactly? And the law did not require that, just that he was able to estimate that it was darker than required by law. So what you have here, you have officers casual encounter, approaching. During that casual encounter, they develop a reasonable suspicion that another crime is occurring. They realize that the defendant is on parole by recognizing him on site. He testified again that it was a 15-year sentence. He knew Agent Norton. Agent Norton recognized him. That would be a substantial sentence that the agent would remember. And agents asked him or ordered, even if they ordered him out of the vehicle, immediately developed probable cause of a further crime because they were able to observe a gun in his waistband. And so at that point, yes, he is seized, he is detained, they are investigating another crime. And none of this should be subject to suppression. Thank you, Judge.
Baker?
I asked the person here, 20 years old, unmirandized, hey, you underage because I want to arrest him. It's essentially another violation that's occurred in this stop. Here's the fact of the matter.
Was he arrested at that point?
They cited him.
I mean, but when they asked him the question, was he arrested in custody? That's where Miranda applies. In custodial interrogation is where the Miranda rights apply.
Well, I don't know any 20-year-old with two officers decked out in tactical gear and guns asking you questions wouldn't think that he's in custody or free to leave. I mean,
I just questioned whether or not I had misunderstood. So.
Yeah. So, the fact of the matter, I'm not going to belabor the point. The fact of the matter, I got an officer stops the car here on a hunch, does a warrantless search of the window tint car. I mean, basically what I'm saying, I'm going to pull you over and do a search, make sure your car's in compliance. I don't need a warrant. I just say it is because I think so. Why does both officers go, well, how many times were you wrong? Both of them, and it struck me as odd. Oh, I don't recall. You know why you don't recall? Because one, they don't record them. Two, it's not good for yourself, and there would be no record of them because you're not going to charge somebody when you're wrong. So of course, your record's going to look flawless on paper. I am right 100% of the time. 100% of the time, because nobody records like DUIs until here recently when I'm wrong. The fact of the matter, you stopped a car, you had no articulable, a reasonable articulable suspicion. You can't articulate the standard.
You do. I'm sorry if I keep interrupting you, but you heard the statute that was read, correct?
Uh-huh.
Does the statute require that an officer be able to give an articulable suspicion, or does it simply say it is probable cause for a post-certified law enforcement? Whether I agree with it or not, and I understand your point, but it says it is a probable cause for a post-certified law enforcement officer of the state to detain a motor vehicle being operated on the public roads, streets, or highways of the state when the officer has a reasonable belief that the motor vehicle is in violation of subdivision A1 for the purpose of conducting a field comparison test. Now there's your point about should they have to have a warrant. I understand what you're saying.
Judge, if we're going to turn the entire country over to law enforcement, they don't need me, you, or this DA right here. Agent Norton should have just pulled everybody out of the car, and if he deemed it necessary, because I've already deemed he's in violation of the law, because the legislature said I can just pull you over now, because it's now probable cause. Matter of fact, I think what the legislature should do, because they're a really bright bunch up there, say that if an officer sees something irregular, that's probable cause for anything, because that's basically what they said. I don't need courts. I don't need magistrates. I don't need anything neutral and detached here. I'm just going to write it into the law that that's automatic probable cause. Problem solved. We're all out of a job. Country's great. That's what we should do. I believe May Beavers introduced a bill up at the legislature where, you know, the court system couldn't declare laws unconstitutional. I'm surprised that one didn't pass. That was actually introduced in our legislature. Just because you pass something and on the book, doesn't make it constitutional, doesn't make it lawful, doesn't make it legal. And I can name
The
numerous
mistake that I
occasions.
made was I asked you if you understood what the language of the statute said and then I read you the statute. I understand your objection to that idea. I understand your argument about it. But let's move on. Was there anything else you wanted at 4 o'clock on a Friday?
I'm good, Judge.
General, you have anything else? Well, I'm going to take this matter under, is Mr. Warren set for trial?
So,
Well, obviously, this has got some,
and Judge, if you, I don't mind, I know he's in custody. If we have to move it, I would like to do a supplemental brief on that parole issue. There's some federal case law that says just because somebody's on probation or parole does
you
not,
got 7 days to do your supplemental brief.
Okay.
It's due on Friday the 12th.
sounds good, Judge.
State can can respond to your supplemental brief by the 19th, but I'm going to render a decision in this case prior to the trial date. Trial date remains the same.
Thanks, Judge.
We will adjourn court.
Just starting with 4035, 114, I would believe that factor one could apply. It's not for range purposes, but he does have an admitted prior conviction for DUI and reckless endangerment out of Kentucky. I would also argue that factor four would apply. The victim was a 2 to 4 month old baby. I don't know how anyone in their life gets more vulnerable than that. So I would certainly think, because of the age of the child, that factor would apply. I would also argue that number 5 applies. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the crime. All he had to do was seek help and tell the truth about what happened, and we probably wouldn't be here, or at least not here in this capacity today. I think, even based on his testimony, he was trying to mitigate and hide what had happened. He did not seek attention. Ms. Petty, according to his testimony and her statement in the pre-sentence report, took off work the next day, and she was the one who initiated that. But for her, I don't know if this child would have ever been seen by a doctor. I'm glad it was, but it wasn't because of him. I've got 2 kids. Everybody in this room probably has kids. If I fell on top of a baby, the immediate thing I'm doing is seeking medical attention, no matter what. And he did not. So I would argue that number 5 would apply. I would argue number 6 would apply. The personal injuries inflicted or the amount of damaged property sustained was particularly great. Skull injuries, broken ribs, broken limbs, seizures. I would certainly think those would meet that factor for particularly great injuries. He says the child has made a full recovery. I mean, Your Honor has heard the testimony about how this kid came into their custody. Not the best start in life for a child, but, and the mother isn't here today for, I think, reasons the court can infer. And I don't know if the child's made a full recovery, but I do know the injuries sustained were not ungreat. And lastly, I would argue that factor 14 would apply. The defendant abused a position of public or private trust. Certainly private trust. The mother of the deceased father of this child trusted him every day while she went to work because he says he can't. And I know Your Honor has medical proof that would tend to back that up. in any event, he was trusted with the care of this child. And I would argue that he failed horribly in that regard. So I would think 14 would apply. State's going to ask for 10 years to serve. I know he's got medical conditions, and we have Department of Corrections facilities that can handle those for him. I understand everything that he has said today. I think this is probably the closest to the truth that we'll ever get, but he's not been very consistent. He says he doesn't know and has honored the no contact. Then he says he knows the current condition, which I'm sure he does know through his friend, girlfriend, whatever they are. But then he says he saw a video. And he claims he told a consistent story from the beginning. And based on the pre-sentence report and his testimony today, that's just not true. He has not. He originally claimed he dropped this child 2 feet, roughly, from a bouncy chair, and he hit his head. And the whole reason we're here today is because the Vanderbilt Child Care Team said these injuries, based on that, are impossible. And now we know that they are, because he literally fell like a tree onto a child and did nothing about it. The only thing he's done about it to this point today, from anything I've read about this case, is try to mitigate it and excuse it. And there's no excuse for that, in my opinion. So that's what the state's asking the court to do.
Mr. Poland?
Your Honor, I think that we can all agree, all of us can agree, that this young child, Levi, has had a horrible start to his life, and we can only hope that he has actually made a full recovery. Your Honor, after looking at the factors in 40, 35, 113 as mitigating factors, I point to number 8, the defendant was suffering from a mental or physical condition that perhaps significantly reduced the defendant's culpability for the offense. It does discuss voluntary intoxications, which is not applicable here, Your Honor. We have presented proof to this court that his beginning of his disability started on or about this time when he was in the care of the child. Your Honor, my client has exhibited symptoms today that have become full circle with his disability. We are arguing that he has an alternative sentence of probation or some type of alternative sentence other than prison. Your Honor, he is remorseful for these acts. He claims that these were accidents, strictly accidents. He has testified today, Mr. Jones has testified today, that the ambulance was called. The ambulance was called when he noticed there were injuries to the child, which was the next day with him and Miss Tammy Petty. Your Honor, there's not been any indication that he intended to hurt this child. His rendition of his stories may be cloudy based upon the situation at hand with the child being injured. Your Honor, I'm asking for my client to be sentenced appropriately to probation or an alternative sentence other than prison. Thank you, Judge.
Two things. As far as he didn't know his medical condition at the time, so he even said that. So I don't think that mitigating factor applies. But lastly, I'm just going to really disagree with the remorseful part. And Your Honor's recollection will have to trump mine, but I don't think he said I'm sorry one time when he testified. He's remorseful about the consequences, and he wasn't remorseful enough about what had happened to seek medical attention. And today, all we've heard is a sob story, and I'm sure he is in pain. And I'm sure he does have back issues. Like I said, I broke my neck when I was 19. I got the same problems. But that has nothing to do with this child and the remorse for it. I don't think there has been any remorse. Just a lot of excuses, a lot of woe is me's, and not one time have we really focused on who got hurt. So I just disagree with that part.
All right, let's talk about that. Watching work through this sentencing was like watching someone hold a scale weighted with law on one side and raw human tragedy on the other, steady, precise, and unwilling to let sentiment cloud the record. The state came out swinging, pointing to aggravating factors under Tennessee's sentencing statutes. Prosecutors emphasized that the victim, an infant just 2 to 4 months old, was as vulnerable as it gets. They argued the defendant acted with exceptional cruelty by failing to seek medical attention, leaving the child with skull fractures, broken ribs, seizures, and catastrophic injuries. They stressed his role as caretaker, placed him in a position of private trust, and that trust was horribly abused. Their ask, 10 years to serve, citing not only the brutality of the injuries, but also Jones's shifting stories, first claiming a 2-foot drop from a bouncy seat, then later testifying that he collapsed on the child due to a spinal condition. Counsel countered by framing the case as an accident compounded by disability. They argued Jones's degenerative back issues reduced his culpability, pointing to visible symptoms in court and medical records showing the progression of his condition. They pressed for probation or an alternative sentence, highlighting his claimed remorse and the fact that he eventually sought help. But even here, the cracks showed. Prosecutors pounced on the fact that Jones never said "I'm sorry" during testimony, insisting his concern was more for himself than for Levi, the baby who suffered the injuries. Judge W. Actions revealed both skepticism and control. He noted that just because the legislature authorizes probable cause for certain stops doesn't automatically make it constitutional, drawing a sharp line between statutory permission and judicial oversight. He also challenged whether Jones's condition excused the failure to get immediate medical help, questioning how any reasonable caretaker wouldn't have rushed a baby to the hospital. His tone stayed calm but probing, never letting either side wander too far without bringing them back to the legal standards. What emerged was a judge balancing law, facts, and human frailty. On one side, a child with horrific injuries, a caretaker who shifted explanations, and a state convinced it was cruelty. On the other, a man in visible physical decline, insisting it was an accident, asking for mercy in the form of probation. Wolfe didn't grandstand. He kept the proceeding grounded, laying the foundation for a ruling that would weigh statutory aggravators against claimed mitigators, ensuring the outcome rested not on sympathy or outrage, but on a clear application of law. It was heavy, it was uncomfortable, and it showed exactly why sentencing in child injury cases is among the toughest calls a judge can face. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.